Hello everyone, I'm Sam. I will be doing for week 3 questions 2 and 4. Okay. So question number 2, is there an aspect of either the civil law or the common law legal system that you consider to be superior to the other and why? So the common law system employs an adversarial model. So you have two opposing parties presenting arguments. The judge's role is a passive in the sense that they listen to arguments, acting as an impartial umpire, and deciding ultimately whose argument was more convincing. In civil law, the inquisitorial model sees the judge actively doing investigative work, seeking the truth in order to decide the case. So on its face, I find the civil law tradition's approach to be more compelling because it places objective truth at the heart of the process. So it's easier to imagine a common law system, how a stronger argument could be made by a better, more costly team of lawyers for a guilty but rich client, which causes an unjust power dynamic to me. And it seems to be baked into the common law adversarial model in ways that it's not necessarily for a civil law system, though I'm sure that there are ways that that money enters into the civil courts, just as I know that truth is valued in the common law system as well. So it's not cut and dried. And that's adversarial versus inquisitorial model there, with inquisitorial being, in my eyes, superior. And I also had certainty or flexibility. So here we have differences between the civil law tradition and the common law. So the civil law tradition places certainty in a prime position above most other factors, and that was from the reading on the civil law that we had, the second reading there in the book. So combined with the civil law tradition's general aversion to judge-made law, the result is a far more rigid system that attempts to address every real-world eventuality in the code itself, so codifying everything. This is an impossible task, I think, and the attempt can be maddening. So the law, in a nutshell reading, explained that the French system recognizes this pitfall to a certain extent, of trying to account for everything, and accordingly stuck to general principles, while the German system made an effort to create a universally applicable laws and got much more in the weeds and in depth. As discussed in the Civil Law Tradition book, there is a propensity among the civil law systems to prize certainty in the law, thereby propose changes that may produce more just outcomes but muddy the waters and make more ambiguous rulings may not be given proper consideration. Common law, by contrast, values and strives for certainty, but not singularly or slavishly. So it is one of many factors, and there is an understanding of the world as an ambiguous place where everything can't be planned for. So that's the difference there. And I would choose flexibility, so I think that the common law system has a leg up there. Question number 4 here we have, the French and German civil systems developed in slightly different manners. What are those differences and what are the primary influence of each? Okay, so we'll start with the French system here. And my head's in the way, but that says revolution there. So the French system, it was written by 4 judges in a very short time compared to the German system. It took influence from prior law, including Justinian law, royal and customary law, and the Custom of Paris, which was written down in the 1600s, luckily for them, and also took influence from Enlightenment ideals in the Revolution. It sought to interpret existing legal structures in accordance with Enlightenment ideals, so putting historical law through the sieve of reason, as they called it. So the overthrow of traditional hierarchy meant there were time pressures, and also because it was more populist in nature, succinctness was necessary so the law could be grasped by civilians. So put the power in their hands so you don't get beheaded. And the result was a code featuring brevity and continuity with the past, but also with that democratic bent, so very important. The three pillars of the French Civil Code mirrored the first three Justinian Institute books, while also showing the French affinity for the United States system of government. So they were private property, freedom of contract, and the patriarchal family. The three pillars laid out in broad strokes allowed the civil law to take on a similar character to the United States Constitution, where it's more broad strokes and less about getting every little detail in specific. So that was on purpose there. So very good. Now we'll talk about the German system here. Okay, so the German system. German codification projects began as an effort to unify a large, loosely connected Germany into one country with a consistent set of laws. So when we talk about nationalism, it's really about getting a sense of German pride, because previously there had been different principalities and different city-states. There was no Germany. So to get those groups together, there was a concerted effort to get a German pride together to mix results, but that's a few years from now. So the German codification process began with that goal in mind, and the consistent set of laws was kind of the basis for that. The project began with an understanding that laws should come from first principles or ethics. So we'll start with abstract ideals, and ultimately that will lead to kind of a golden rule sense of these are the laws in front of us. So the project originally was to do that. Then we had I'm going to butcher this name, Karl von Savigny, and his school of thought put forward the idea that only through historical research of both the indigenous German law and also the Roman law that in large part inspired it, would German tradition and the genius of the German people be uncovered, and that would lead to a German set of laws that was uniquely German and would bring everyone together. So that was the project going forward, and it was German legal historians doing that for 20 years. So it took a long time. Ultimately, the German scholars became infatuated with the Roman laws and developed a highly logical, precise academic code that, in contrast to the French code, was not accessible to the public, was very much cloistered in academic language, but also they figure was of such a logical nature that it could be applied to any situation and was logically consistent across the code. So very, very good for the academics, not so much for the civilians, but it did give them that completeness and precision that they were looking for. So that is my answer to question number 4, and thank you for watching, and we'll see you in class. All right, bye.